Of course, the very last one in the big pile.
I'll over here.
The last should be first. This is your time. 24 CR 2103 is called. The state of Texas versus Lzette Munos is present with Mr. Parker, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about August 4th, 2024 in Jefferson County, Texas, you committed the third-degree felony of engaging in organized criminal activity, which state that in summary, you collaborated in carrying on criminal activity intentionally and knowingly committing the offenses of theft on or about several days that are listed. And there's an agreement that's been reached where you would be pleading guilty to the lesser included class B theft.
Plus, I think it's plus.
It says class B, but it's.
Oh, and maybe it's, that's right. That's right.
That's class.
Yeah.
I mean, I think that's a B, but it's hard. The pads look funny.
Yes, I've got it as a class B.
Okay. Which carries with it up to 6 months, up to 180 days in the county jail and or a fine of, help me on that one.
$2,000.
$2,000 if we don't do that. Okay, this is. I gotta redo all of this because it's written out. So
So it should be in.
nice, darn it. No, fit. Mary, Dan, down there. Where's the house?
I don't care, but yeah, you can.
What's the statute say? 180 days or 6 months? What's the statute say? On class B? I think it's 6 months.
That's right.
What? Yeah, you're there.
Oh, they seemed real confident over there.
Yeah, it's not.
To fine $2,000.
That's true together.
You understand the punishment range? There's an agreement that's been reached here that you would be pleading guilty and sentenced to deferred or unadjudicated probation, and that would be up to 2 years in length. And there is restitution, which is the key. You do that, you get shortened, you get rewarded for paying back restitution.
Paying that today, Judge.
Good. Then it would be shortened, everything else in a third, everything else being the same. Okay. And that's $3,796.39.
Correct.
Okay. If I follow, I'm going to put that. That's 7, because it's 7. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Because
You want to speak up? How do you plead to this lesser included class B misdemeanor of theft, guilty or not guilty? Are you pleading guilty voluntarily, that is on your own free will and because you are guilty? Listen, I'm going to show you what's marked here, State's Exhibit 1. I'm going to ask, did you sign that, discuss it with your attorney, or the contents all true and correct? Yes. State's Exhibit 1 tendered into evidence without objection.
Objection.
Admitted. This states you were mentally competent to enter your guilty plea, which is freely and voluntarily. You know what you've been charged with? Guys, it's been read to you. You've read it. You were guilty of the crime charged. And most importantly, in this disposition, any lesser included offenses, which includes this class B reduction in, as a lesser included offense of theft. You're giving up your rights to a jury trial and the rights to the appearance confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true and safe, so help you God under oath. Yes? Yes. You have soft evidence. The court will, based upon those representations, make findings in support of those representations, that those are true and correct for the record. Pre-sentence report waive. I'm going to find, if nothing further, you were pleading guilty today voluntarily. You're fully competent. It is, you understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am going to defer any findings of guilt and place you on deferred or unadjudicated probation for 2 years. You must pay restitution in the amount of $3,796.39. It's not listed. It just says the
Academy Sports and Outdoors, Judge. Yes, sir.
It is.
We just did the pleas on the others.
there's no, the only names are like co-defendants.
It's 100% Academy.
Okay. It goes to Academy Sports and Outdoors, 8453 Memorial Boulevard, Port Arthur, Texas.
We have the ultimate tradition.
Okay, well, it has to be in the order. And if that's okay.
Yes, that's fine. Said restitution order, I mean, we got it.
No, it has to be listed.
Thought out.
So that if there's any civil relief that they use, they will refer to it and she gets credited for it. All right, the court has signed these orders. Please see the probation officer and you can begin. The quicker you begin, the quicker it ends.
I've been notified, Judge, that we
Sorry,
want
we're going to sit at the end just because it's you.
Okay.
Yeah. Well, who is it?
It's Sultan Barrera.
Okay.
We have an agreement. We just need to work out a couple of things. We could have a few weeks to put on the plea docket.
You got it, buddy.
Come on up.
So who is the defendant? Thank you. Nobody wants to be in jail. That's correct. Okay, he's charged with burglaries of a building, right? And he came 2 state jail felons. Okay. Yeah, what are we gonna do today?
I'll get with Mr. Ham and see if I can get an offer and see if I can figure this out.
See what you can do. Thanks. Get back to the- Thank you. Kishan Washington. 25 CR 75, Christopher Harris, that you, sir? Does he need to sign in front of you or anything?
Is it a plea?
It's a plea,
Oh, okay.
and nothing but a
yes.
plea. So help me God. Does he need to sign in?
Yes, he needs to come swear in front of me and fingerprint his because we can.
Swear in front of her, don't curse.
I can handle it, Judge. Mr. Harris, please raise your right hand and swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay. Ink up your right thumbprint, right finger. Place it flat right there. Keep it up one more time, make it a little larger. I would scan this. Right. Okay, can you go stand on the judge?
And 25 CR 75 is called the State of Texas versus Christopher Ray Harris. That's you?
Yes, sir.
With your attorney, Ms. Manaldi, and the state's attorney, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes.
In summary, sir, this indictment alleges that on or about December 9th, 2024 in Jefferson County, Texas, you committed the 2nd-degree felony of aggravated assault with a deadly weapon, namely a firearm. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation for up to 10 years in length, fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes, sir.
I'm going to ask you to look at that? Did you sign that document, States Exhibit 1?
Yes, sir.
Discuss it with your attorney, or the contents true and correct? Yes.
Yes, sir.
States Exhibit 1 tendered into evidence without objection?
No objection.
Admitted. This states, among other things, that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1 made a part of the record for all purposes, and the court makes findings that those stipulations are in the record, and the court accepts those as true and correct made by the defendant. Pre-sentence report, Wayne?
Yes, Judge.
If nothing further, I'm going to follow this agreement, and I find there is sufficient evidence supporting your guilty plea to find you guilty beyond a doubt, but I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 10 years. You must pay a fine of $500. You do well, it gets shortened to 1/3 of that. There will be terms and conditions normal and customary that the probation officer is going to memorialize in the order. You will be fined $500 as well. You understand what has happened today, sir? Good luck to
And
you.
Your Honor, just for the record, the defendant, we've asked that he have no contact with the complainant in this case, who I believe he lives in Louisiana now anyways, but just for the record for probation, that he not have any contact with Michael Mouton.
Okay. Do you understand that?
Yes, sir.
And that's already been an issue in another case, and we want to make sure that there isn't more problems that develop. Let's fix what we've got here. And Michael Mouton. See, condition 27, you're going to go over these conditions. Condition 27 states have no contact with the victim of the offense, either in person, by telephone, mail, electronic mailing, social media, or through a third party or any way else. So that takes care of that.
Yes, sir.
And that's in every case. So you don't want to lose your probation because of that. Here. Court assigned these orders. And you are on probation, good. Thank you. That is not all.
These books, which they were David's on the initial, and they, once those are approved, they.
Who is Jackie Williams? Come forward.
Judge, Ms. McKinney, who was the very first person we called.
He was here earlier. We had him sign a resetting. He just had to fill out that affidavit.
All right, it's approved. I find the defendant indigent, and attorney will be provided. And in Mr. Hensley.
You're good. He approved it.
Oh.
You're good to go.
Mr. Hensley,
You're correct.
and I'm granting your request. The attorney will be appointed to help you. Try to see what y'all can do on getting that thing done and behind you.
Yes, sir.
So you can move on with your life until it's finished. It's hanging around your neck like an albatross, so you don't want that. Thank you, sir.
Just keep in contact with Mr. Ruff.
Vicky Holloman's case was reset. Javon Narciss.
Now lead,
Mr. Narciss, come forward, please.
okay.
Javon Narciss.
He's a lead.
Mitchell Sylvester is reset.
He was reset.
Okay. And then I've got Patrick Leach next after this case with Brennan Mitchell.
Oh, that's what you're on.
Oh, that's dismissed. Did I read it?
Yes, sir.
Yeah, that's been dismissed.
Yeah, I've got one more, Judge.
Oh, okay. You want me to do another dismissal one?
I know.
I got you, Judge.
Can I get mine for that too? I'm not sure Sarah's gonna.
I'm sorry, John, not you.
Not me.
You're in the bad list.
My sister comes out, you would.
Yeah, probably.
Denied.
Judge, I'll put on the show for a dismissal. I'm it's that, okay.
Yeah, I've seen that and it's. Yeah, I want my money back. Yeah, the last one.
Jimmy, is this the last copy of this?
Yes.
Okay, thank you.
Who's this?
Javon.
Narciss, right?
Yeah.
Mr. Narciss. 24 CR 1940 is called the state of Texas versus Javon Narciss, who's present with Ms. Minaldi. Your attorney and the state's attorney does the defendant waive a formal reading of the indictment and arraignment here. Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about July 30th, 2024 in Jefferson County, Texas, you committed the second degree felony of robbery. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face no less than 2, no more than 20 years confinement in prison and fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement has been reached where you would be pleading guilty based on deferred or unadjudicated probation for 10 years, which can be shortened for good behavior. Fined $1,000, terms and conditions which are normal and customary for that type of offense will be applied. Is that your understanding?
Yes, sir.
And if I follow this, you have no right of appeal of your case and you understand. How do you plead to this charge, sir? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct? State's Exhibit 1 tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea as freely and voluntarily made. You know what you've been charged with? Your indictments can go to you. You were guilty of the crime charged in only lesser included offenses. You were given up legal rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All truth so help you God. State's Exhibit 1 made a part of the record, sworn to by the defendant, and the court will make findings that into the record that are in accordance with those stipulations, waivers, and judicial admissions in State's Exhibit 1 that is offended as acknowledged, and I find are true and correct. Present truthful way.
Yes.
I'm going to follow this agreement and find, sir, nothing further. You're pleading guilty today voluntarily. You're mentally competent, so you understand and appreciate the consequences of pleading. There's sufficient evidence supporting the guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to defer any finding of guilt as long as you follow these terms and conditions of probation that the probation office will make sure you understand. It'll be a fine of $1,000 and other terms and conditions, which are normal and customary for this type of offense. Make sure you follow this. Okay. Thank you. Yes, sir.
Judge, Mr. Parker wants to know if he'll take his plea next.
Who?
Mr. Parker.
No, anybody different.
Judge, I'll have.
Okay, thanks.
Thank you.
Alan, where are you? There you.